Good afternoon, Your Honor.
Good afternoon. Do you need more time, or we have anyone that's ready?
No, Mr. White is ready.
All right. Good afternoon, Mr. White. All
Your
right.
Honor, we're set on this for pre-trial. As you're,
Let me call it real quick, just so I can have a record marker. Okay. This is cause number CR 22-130 and 131, State versus Shayna, Sapien, and Dobie. Sorry to interrupt, Mr. White. Go ahead.
no problem. As the court's aware, I was appointed on this case somewhere around December the 12th. The court had ordered the previous attorney to provide us with some information or everything that they have on had on this case. Now, for the record purposes, I'm going to tell the court Mr. Fratter personally never provided me with anything. I received 2 binders with written discovery in it from the investigator that I think the court may have appointed. I know he asked for that appointment. I don't know if the court ever approved that. I know he was working for Ms. Dobie at the request of Mr. Fratter prior to they're asking for an additional funds on that. I received a external hard drive on that. We have managed to go through almost all of the hard drive, Your Honor. There are a number there. I'm guessing there's close to 500 or so phone calls. We haven't quite got through all those yet. And I think I've received most of the paper discovery. All that to be said, because I wanted that on the record, obviously. The discovery is extensive. There are some documents that I am not sure I would generally suspect to see in this type of case, and I have not seen them yet. Because of the nature of the external hard drive, some of the documents and audio, for lack of a better term, I know this is probably not a computer science correct term, but it's almost like embedded. And I don't know if that's the way that they had received it. I kind of suspect maybe not from the DA's office. It was moved around and put into different files. I think the investigator and maybe Mr. Fratter had tried to clean it up. I don't know, but we've had some difficulty locating some things. And before I said that, hey, look, we didn't necessarily receive everything, I wanted to make sure that we had gone through it. I do believe that there are some text messages that we've had. I know I don't believe it. There's some text messages I think that are there. And if they are, we have not been able to locate them yet. With all that being said, I'm going to need a little more time on this to determine whether or not. I know we're still specially set for September, Your Honor. I see no reason that if this should go to trial that I will not be ready by that date, but I would ask that the court, given the unique circumstances that presented on this case, that we be allowed another 30 days to kind of see if we can determine what we're going to need to do during pre-trial, if anything. Looking at the case, that what had been done before, it doesn't appear to me that the previous attorneys filed any sort of motions regarding search warrants or any other thing. I also don't believe that there was any discovery motions filed requesting the state to provide specific information that may exist. Normally on something like that, I sit down with Ms. Curry or Mr. Harwell, tell them what I need, and I've never had any problems getting that. I know that the court had instructed Mr. Fratter to provide me everything He had sent me an email in which he said that he was going to send me some emails and some other things regarding discovery. He never did. I certainly don't want to waste the state's time in asking them to provide me things that they've already provided. But I've gotten very little, no cooperation from that office. Now, to be fair, Your Honor, after they took so long to get me, I did not get the documents and everything on discovery that you ordered them to turn over till after Christmas. I picked them up on December 26th at the post office. They were postmarked on the 23rd. With that being said, I don't want the state to have to duplicate their efforts. But once we've gone through everything, and I think we pretty much almost have, I'll sit down with the state and ask if they provided it or not. And if they haven't, I'll get it from them. But given how long Ms. Dobie's been incarcerated, I'd ask the court to set this over to March. And so we can just at the very least give the court an update about where we are. And if we need the court to make any sort of specific rulings regarding discovery that hasn't been provided, that would give us a chance to do that.
What about bumping out a little bit longer? What about April 16th? That way you got more time to go.
Your Honor, that would be just fine.
Any objection from the state?
No, Your Honor.
Okay. Court's going to set Ms. Dobie for an additional pretrial hearing on April 16th at 1:30. And I guess, Mr. White, if it's ever required or necessary, we can always summons Mr. Fratter here to court and put him under oath and find out what discovery he has turned over, which one he hasn't. So obviously, you know what your remedies are on that, but should that be needed, you'll just notify the court and we can get that done.
I will, Your Honor, and I'll sit down with either Mr. Hartwell or Ms. Curry and see exactly what has, if we think we're missing something. I think there are a couple things I'm missing. But just quite frankly, I received a letter attached to the discovery I did receive from the investigator on this matter. And he had mentioned several things that they didn't feel like that they had been provided. There's no other way to say this. I don't trust it. I'm just going to say that after having reviewed it, and given the amount of time that we've spent, and I think maybe even a couple of things that they maybe addressed in there, I think maybe we actually did have, it just had to look for it. So with that being said, I don't necessarily trust anything I'm getting told on that end, and I would just assume deal with the DA's office.
Okay. All right. Well, you'll notify the court between now and then if you need additional assistance.
I appreciate y'all. Thank you.
All right. Well, Dobie, we'll see you back on April 16th.
Yes, sir.
Who's next, Mr.
Yeah, all right. Okay. Is our interpreter on yet?
No, ma'am.
Okay. You'll just let me know.
We'll do.
She's already done her.
John.
All right, Miss Roberts is here and she has signed her paperwork from this morning.
Okay, good.
Okay.
You want to get him, that's fine, because I'm ready on the
He's
phone.
still doing his sleeping.
All right, I'm ready.
All right, Mr. Richard Smith is up.
All right, Mr. Schmidt, good afternoon. Who would you like to call first?
Michael Whitten.
Court calls cause number CR 24-9, State versus Michael Joseph Whitten for arraignment. Go ahead, Mr. Schmidt.
That's correct, Judge. We received a copy of the indictment. Mr. Whitten's name is spelled correctly. We understand the range of punishment. We'll waive formal reading of that document and enter a plea of not guilty and ask for a pretrial setting on the April 16th docket if that's available.
All right, court sets Mr. Whitten for pretrial hearing on April 16th at 1:30. The court finds that Mr. Whitten has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the.
Thank you. Marshall Parker.
State calls cause number CR 23-31, State versus Marshall Deshaun Parker for arraignment. Go ahead, Mr. Schmidt.
Correct, Judge. Same announcement. We received a copy of the indictment and understands the charges against him. We'll waive formal reading. Enter a plea of not guilty, ask for a pretrial setting on April 16th.
Court says Mr. Parker for pretrial hearing April 16th at 1:30. Finds that he's waived the formal requirements of arraignment. The court enters his plea of not guilty into the.
Lunsford.
Brian Lee Lunsford, CR 24-6 for arraignment. Go ahead,
Judge, I received a copy of the indictment. We understand the charges. Name spelled correctly, waive formal reading, enter a plea of not guilty, ask for pretrial April 16th.
Court does set Mr. Lunsford for arraignment, for pretrial April 16th. At 1:30, enters his plea of not guilty into the record, finding he's waived the formal requirements of arraignment.
Mr. Arnold.
Court calls State of Texas versus Tony Byron Arnold, CR 23-173 for plea. Is that still what we're doing today, Mr. Schmidt?
It is.
All right. Mr. Arnold, good afternoon, sir.
Yes, sir.
Mr. Arnold, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you, sir. All right, your name is Tony Byron Arnold, is that correct?
Yes.
And Mr. Arnold, are you a United States citizen who reads,
Yes.
writes, and speaks English?
Yes.
And in this case, well, let me ask you, have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes.
Feel like you've had enough time to talk with him about your case, have all of your legal questions answered?
Yes.
Is there anything about your plea agreement or the paperwork that you've read over and signed today that you do not understand?
No, I understand it.
Mr. Schmidt, do you believe Mr. Arnold to be competent?
Yes, sir.
And you believe that he's entering into this plea intentionally, knowingly, and voluntarily?
I do.
I see the proposed plea agreement is to the third-degree felony prohibited substance in a correctional facility. Mr. Byron would be pleading guilty to that in exchange for the state's recommendation and a plea agreement to 10 years confinement in the Texas Department of Criminal Justice, a $1,000 fine plus restitution, court costs, reimbursement fees, and the state would be asking the court to dismiss an unfiled resisting arrest, search, or transport, and that Mr. Arnold, upon accepting a plea, would receive 293 days credit towards his sentence for time he's already been in jail. Is that your understanding, Mr. Schmidt?
Yes, sir.
Is that your understanding, Mr. Arnold?
Yes.
All right, Mr. Arnold, the range of punishment for a third-degree felony is not less than 2 years in prison or more than 10 years in prison. It carries a fine not to exceed $10,000 if imposed. The court finds that the plea agreement does lawfully fit within the range of punishment. Mr. Arnold, at this time, how do you plead to prohibited substance or item in a correctional facility?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty today?
No.
Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
No, sir.
All right, I don't think I have the stipulation of evidence. If either counsel has that, could you assist the court and read that into the record?
Sure, Judge, I can do that through the courts.
Thank you, sir.
On or about April 26, 2023, in Van Zandt County, I, Tony Arnold, was staying at the Days Inn in Canton, refused to leave when my reservation had ended. Manager called Canton PD, who arrived. When they checked an ID, they found that I had a warrant. I was arrested and taken to the Van Zandt County Jail, where it was discovered that I had what the DPS lab confirmed to be 1.16 grams of methamphetamine.
Thank you, Mr. Smith. All right, based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Arnold of this offense. The court will follow the plea agreement today between the parties. The court hereby convicts Tony Byron Arnold of prohibited substance or item in a correctional facility, a third-degree felony. Assesses his punishment pursuant to the plea agreement at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders him to pay a $1,000 fine, $180 in restitution, $290 in court costs, and $20 in reimbursement fees. Further, the court dismisses under section 1245 DA 2023-484 a resisting arrest, search, or transport. Mr. Arnold is awarded 293 days credit towards the sentence for the time that he has spent in jail on this cause. Mr. Arnold, you hereby remain into the custody of the sheriff so he can carry out the terms and conditions of the sentence. Step over with the deputy to be fingerprinted. Good luck to you, sir.
Thanks.
Mr. Schmidt, Ms. Grisham wanted me to pass a message on to you. She didn't say it so much as I saw it in her eyes, but she says the next time she sees you, she's going to remind you how she feels when you talk so fast, make her fingers hurt. That's, like I said, I'm just paraphrasing based on facial expressions.
And in retort, Judge, I'd say that I realize that this is on YouTube. So there you go.
There you go. There you go. Like I said, just my interpretation.
Fair enough.
All right, this is cause number CR 21-00308, State of Texas versus James Clifton Rife. Mr. Rife, sir, if you'll raise your right hand, I'm going to place you under oath. Mr. Rife, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you, sir. All right, Mr. Rife. Give me just one moment. Let me flip back here in your paperwork. All right, Mr. Rife, you appeared before this court on February 21st, 2023, and you pled guilty as part of a plea agreement to possession of a controlled substance of penalty group 1, a third-degree felony. On that date, the court heard the evidence in your case, and the court followed the plea agreement that you reached with the state. And the court assessed your punishment at 10 years confinement in prison, along with a $7,500 fine. The court then suspended that sentence and placed you on community supervision. It was during that period of community supervision that the state of Texas filed its motion to revoke your community supervision, and they alleged 4 separate counts of various violations. Have you had sufficient time to read over that and review your case with your court appointed attorney?
Yes, sir, Your Honor, I've read it plenty of times.
All right, are you pleased with Mr. Schmidt and the work he's done for you?
Yes, Your Honor.
Is there anything about your plea agreement and the paperwork you've signed today that you do not understand?
No, Your Honor.
All right, Mr. Schmidt, do you believe Mr. Rife to be competent?
Yes, sir.
And you've explained to him his rights regarding this case?
I have.
And does he intend to plead true to all 4 counts? Is that part of the agreement?
That's correct, Judge. We plead true to all counts and wait formal reading of the motion to revoke.
Thank you, Mr. Schmidt. All right, Mr. Rife, I ask you at this time, sir, how do you plead to counts 1, 2, 3, and 4 in the state's motion? Are those counts true or not true?
I reckon they're true, Your Honor.
You reckon they're true? Does that mean that they are true?
Yes, sir, Your Honor. I reckon they're true. Yeah, they're true.
Okay. All right, and Mr. Rife, no one's threatened you, forced you, or pressured you to plead true to these counts, is that correct?
No, Your Honor.
All right, court will accept the defendant's plea of truth to each count as alleged. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights of plea of truth?
No objection.
That is admitted and the court takes judicial notice of the defendant's judicial confession. Anything from the state,
Nothing further, Your Honor.
from the defense?
No, sir.
All right, Mr. Wright, then based on your plea of truth and the state's motion, the court finds that you have violated the terms and conditions of your community supervision. Court will follow the plea agreement you've reached with the state today. Court hereby revokes your community supervision, assesses your punishment at 7 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders you to pay the balance of your financial obligations, which I believe at this point is just a $50 reimbursement fee, because I believe you paid off your fines, restitution, court costs. Furthermore, Mr. Wright, the court awards you 122 days credit towards your sentence for time that you've already spent in jail on this cause. Mr. Wright, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Good luck to you, Mr. Wright.
Thank you, Your Honor.
You're welcome. See you soon. Who's next, Mr. Schmidt?
Robert Wayne Glass.
All right, Mr. Glass, come on forward, sir. This is cause number CR 23-160. Mr. Glass, if you'll raise your right hand, I'll place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. Your name is Robert Wayne Glass, is that correct?
Yes, sir.
And Mr. Glass, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No.
You're represented by your attorney, Mr. Schmidt. Are you pleased with his representation?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today as part of your plea agreement that you do not understand?
No, sir.
Mr. Schmidt, do you believe Mr. Glass to be competent? And if so, have you explained to him his rights pertaining to this case?
I have on both counts, yeah.
All right, Mr. Glass, you are charged by indictment with a second-degree felony offense of possession of a controlled substance of the name of 1 between 4 grams and 200 grams. A second-degree felony does carry a range of punishment if convicted and sentenced to not less than 2 years in prison or more than 20 years in prison, and a fine if imposed not to exceed $10,000. I see the plea agreement in your case is that you would plead guilty to that crime in exchange for the state's recommendation for your sentence to be set at 4 years in prison, along with a $1,000 fine plus restitution, court costs, and reimbursement fees. In addition, the state would be dismissing, evading arrest or detention, and you would receive 357 days credit toward your sentence for the time that you've already been in jail. Mr. Glass, is that your understanding of the plea agreement?
Yes, sir.
Yours as well, Mr. Schmidt.
That's correct.
All right, Mr. Glass, at this time, I would ask you, how do you plead to the second-degree felony offense of possession of a controlled substance?
Guilty.
Are you pleading guilty to this crime because you are guilty of committing
Yes,
this crime?
sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
No, sir.
Court's going to review the stipulation of evidence. All right, if the court finds that based on the stipulation of evidence, there is sufficient evidence to convict Mr. Glass of this offense. The court will follow the plea agreement today, finds that it is a lawful sentence within the range of punishment. The court hereby convicts Robert Wayne Glass of possession of a controlled substance, felony group 1, a second-degree felony. Assesses his punishment at 4 years confinement in the Texas Department of Criminal Justice. Orders him to pay a $1,000 fine, $180 restitution, $290 court costs, and $105 in reimbursement fees. Court dismisses DA 2023228, evading arrest or detention, and that's taken into consideration with this resolution in this case. Furthermore, the court does find that Mr. Glass has already served 357 days time towards the sentence, so the court will award him that credit time. Mr. Glass, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Go ahead, sir. Mr. Abraham,
Yes, Your Honor.
there's no interpreter. Didn't you say 2 o'clock?
What we had down.
Hmm.
I'll check with them.
Okay, I was just gonna let you know it's 10 after 2, not
Okay.
interpreter.
Okay, hang on just a second. Miss Merle. Might give me just a second. Your Honor, this is Tina Merlot. Is it Merlot? She's here on a motion to revoke, and she says that her husband is going to hire an attorney.
All right, this is cause number CR 17-418, State versus Tina Marie Morola. All right, Ms. Morola, so you're indicating that your husband's gonna hire an attorney, a private attorney to represent you?
Yes, sir. I just got out of Woodman in 2021 and I thought they ran concurrent with Kaufman County. So, I mean, I'm kind of I missed here. I thought I already did my time because when I moved to Parker County, they ran Van Zandt and Kaufman together as one probation. So when I went to Woodman, I thought,
But I've had probation check, and Ms. Matura said that that Van Zant's was not taken into consideration.
Was it ever resolved or was she considered an abscond?
I don't know, sir. I mean,
Well, no, it's okay. I was asking Ms. Abraham.
I'm sorry.
It's okay.
Ms. Matura is looking.
I'm gonna pull up the sentence real quick and see if she was.
This is the VZC MTA is still open. Using stage one for Kaufman County.
It says ours is open. She was an absconder and she was sentenced on Kaufman County.
So our motion to revoke or adjudicate warrant was served just this month. Second, it looks like. Okay, and so Ms. Marola, were you transferred to our custody from the TDC?
No, sir. Whenever I left well, first of all, when I got in there, they said they would contact Van Zandt County, let them know where I was. And they did not show up to get me whenever I was released.
All right, so we do still have this pending case open, and so an attorney may be able to help you resolve that. So at this point, I'm just inquiring about that. Are your family gonna hire an attorney? You gonna be able to hire an attorney? Okay. Do you know about how long that may take?
I will hire one Thursday.
Say again,
Thursday,
Thursday?
8 a.m. is Thursday, yes.
All right, so let's see. 7th is full. I'll tell you what I'll do, Ms. Marola, I'm gonna set you on the 29th, so that's just a little over 2 weeks. And if your attorney gets on the case and needs more time, then I'll grant more time, but I'll bring you back where maybe your attorney can work something out with the state. So we'll put attorney status and then, attorney and then motion to revoke.
You're at the jail. I mean, at the courthouse and that's what.
Can I ask for a bond reduction? It's $100,000. No,
That's what an attorney.
That's something your attorney can work with you on.
Hey, Your Honor, on Ralph Hensalka, I believe he's here on a motion to revoke. He has completed his affidavit of indigency, I guess last night.
Yeah, they got something.
And so does your wife not lose? So I mean, how long? So he gets SSI disability. His expenses are more than his income, and you don't have a car, you're not paying on a car. So I'm going to appoint the Honorable Jonathan Manning.
Okay, then let's reset, Mr. So let's. Mr. Manning be available on the 29th, do you know? No vacation. All
I believe so.
right, let's go ahead and reset him to 2/29. That's the evidentiary date anyway. That'll give Mr. Manning an opportunity to get with the state. All right, Mr. Anselka, the court's going to appoint the Honorable Jonathan Manning to represent you. Mr. Manning will be giving you information, and you'll be given some information on how to contact him. He'll come see you in the jail and get up to speed on your case. We'll have you back here in about 2 weeks.
I'll send it out with the order. You just vote. Okay, Mr. Stripe is ready on Mr. McMahon.
Okay. All right, court calls number CR 23-61, State versus Johnny Lee. Mr. McMahon, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
I thank you for your hand. All right, are we doing the plea agreement today? Is that still the plan?
Yes, Your Honor.
All right, is your name Johnny Lee McMahon?
Yes, sir.
And Mr. McMahon, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
And you're represented by your attorney. Is it Strife or Street?
Strike, Your Honor.
Strife, that's right. Represented by your attorney, Mr. Mark Strife. Are you pleased with Mr. Strife and the work he's done for you?
Very much, yes, sir.
Feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over today as part of your plea agreement that you do not understand?
No, sir.
Mr. Strife, do you believe Mr. McMahon to be competent?
I do believe so, Your Honor.
And have you explained to him his rights as they pertain to this case?
Yes, Your Honor.
And do you believe that he's entering into this plea intentionally, knowingly, and voluntarily?
I do believe so, Your Honor.
All right, Mr. McMahon, you are charged by, I think you were charged originally by indictment with a state jail felony offense of engaging in organized criminal activity. However, today I see that the plea agreement is that you would plead to a lesser included offense, a misdemeanor assault causes bodily injury. The state's recommending that you be convicted of that offense, that your punishment be assessed at 9 days in the county jail. You receive credit for 2 days of time already served. You be ordered to pay restitution in the amount of $1,003.13. Mr. Stripe, I want you to do me a favor. Look on the first page of that judgment. And there's two places where restitution is referenced. One is in the terms of the plea bargain, and then one is a little further down where you see fines, court costs, and restitution. Does that restitution say 0 at the bottom?
At the bottom, restitution says to be determined, and actually, Your Honor, we just got a new judgment. The restitution was never discussed in the plea agreement originally, and actually a couple weeks ago, we were supposed to have a plea. That judgment had no mention of restitution whatsoever. And so I've talked to Mr. Hartwell, and we've agreed to go through the plea today, and we can have a restitution hearing regarding any potential restitution at a future point.
this hearing to determine that? Because here's my concern, if I'm to pronounce sentence today, then we're gonna have a judgment of conviction. If it's to be determined, I'm trying to think how we're gonna produce another, order of restitution, we're gonna have to, I guess we'll have a separate restitution.
A restitution hearing, yes, Your Honor. State can present evidence. We can provide our argument at that time.
All right, is there anything else that's changed about this plea agreement that I don't have? So what I'm showing was 9 days in the county jail, credit for 2 days. You're saying at this point, no restitution at this point. Restitution to be determined at a hearing, so mark that out.
Correct,
And then Mr. McMahon is to begin serving his sentence on his remaining time today.
Correct, Your Honor.
0 fine, $270 in court costs, $35 in reimbursement fees, and then 2 days credit.
That is correct, Your Honor.
Okay, thank you. All right, Mr. McMahon, is that your understanding of the plea agreement?
Yes, sir.
All right. All right, Mr. McMahon, then, the range of punishment for a class A misdemeanor, if convicted and sentenced, cannot exceed 365 days in the county jail, nor a fine, if imposed, can it exceed more than $4,000. I see that the plea agreement in this case does lawfully fit within the range of punishment. So, understanding the plea agreement and the range of punishment, Mr. McMahon, how do you plead to the class A misdemeanor offense of assault causes bodily injury?
Plead guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, force, or pressured you to plead guilty? All right, then the court will accept Mr. McMahon's plea of guilt. Mr. Schreiber, any objection to the stipulation of evidence supporting this plea?
No, Your Honor.
All right, stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
And Mr. Hartwell, is there any issue regarding victim notification or compliance that the court needs to be aware of?
No, Your Honor. State is in compliance.
All right, the court's going to review the stipulation of evidence. All right, then based on the evidence before the court finds sufficient evidence to convict the defendant of this offense. The court convicts Johnny Lee McMahon of a class A misdemeanor assault causes bodily injury. Court assesses this punishment at 9 days confinement in the county jail. Court awards Mr. McMahon 2 days credit for time already served towards his incarceration. Court does not order a fine, does order court costs of $270 in reimbursement of $35. Court finds that at this time that there is a restitution claim that is to be determined at a later hearing. And that Mr. McMahon's sentence will begin today regarding the additional 7 days confinement. All right, let's look at our, before I pronounce sentence, let's look at our calendars. How long is the state requesting a certain period of time for the restitution?
Your Honor, I think we could probably get it done. The March contested would probably be the easiest.
Are you expecting a lengthy hearing?
Not lengthy, Your Honor. I expect maybe one witness, maybe two.
What about you, Mr. Schreiber?
What date would that be, Your Honor?
That would be Thursday, March 28th.
Would that be in the afternoon or would that be in the morning?
We would set that in the morning because your client will not be in custody.
Okay. I'm sure the firm can send somebody, just make the court aware that as of this Friday, I'm no longer with the firm. But there are attorneys that'll be replacing me out in this county. So that shouldn't be a problem. So March 28th at 9 a.m.
March 28th at 9 a.m. Yes, sir. All right, the court will set Mr. McMahon for a restitution hearing, March 28th at 9 a.m. And Mr. McMahon, you'll report here to the courtroom, okay?
Yes, sir.
All right, court hereby remands Mr. McMahon to the custody of the sheriff so he can carry out the terms and conditions of the sentence. So Mr. McMahon, if you'll step over with the deputy to be here.
Maybe excuse your honor.
Yes, thank you, Mr. Stryker. Mr.
Thank-
Stryker, where are you headed to? You said-
I'm actually opening my own practice in Fort Worth. So I'll do, state and federal criminal defense and also criminal appellate.
All right, well, best, I don't say good luck because I don't believe in luck. I say hard work and best wishes.
Thank you.
All right, Mr. Schmidt.
Mr. Tom, that's Tom. That's the driver's license.
It's gonna be Victor Dean Thomas.
That's correct, Judge.
All right, I'm picking up a lot of background noise. So
We have somebody who's having a mental episode out here, so there's nothing we can do about that.
do we need to take a break and give them an opportunity?
I don't think they're gonna be able to get that individual under control, and I don't think he's on the docket, Judge, so we're just gonna have to speak up.
All right, we'll work through it then.
Yeah,
All
we're
right,
sorry, it's just loud.
that's, I understand. All right, court calls, cause number CR 15491, State versus Victor Dean Thomas. Mr. Thomas is set for arraignment today. Go ahead, Mr. Schmidt.
He is, Judge. He understands what he's charged with. I've received a copy of the indictment. His name's spelled correctly. We waive formal reading, enter a plea of not guilty. Judge, I'd ask for a pretrial setting. I think you have a February 20-something docket date. If you do, we'd like to get him on earlier. If you'll notice, the cause number is quite old. I think that if I sit down with Mr. Hartwell, we can resolve this and get this over with quicker rather than later.
Let me look real quick. We do have the 27th, but we're already at max capacity. We're at 75 cases that day. I could do the 29th. That's an evidentiary day. It's a Thursday.
I'll accept that. If you could give us that date, we'll do that one.
Okay, let's do that. Mr. Thomas then is set for pretrial on February 29th at 1:30.
Yes, sir.
Mr. Schmidt, give me just one moment. Don't step away. Take just a second.
I got back that.
All right, my apologies, Mr. Schmidt. Who do we have with you?
This is Tyler Burnett.
All right, this is cause number CR 23-174, 175, and 176, State versus Tyler Shea Burnett. Are we set for plea today, Mr. Schmidt?
We are, Judge. We're pleading to CR 23-175.
All right, Mr. Burnett, if you will raise your right hand, sir, I'm gonna place you under oath.
Court is frozen on us. I can see Mr. Hartwell moving around. Judge Chris Martin is frozen solid.
Sir, do you swear that the testimony, the truth, the whole truth, and nothing but?
Yes, sir. Yes, sir.
I see Mr. Hartwell. There we go. I can see you now. Okay, we all paused for just a second. All right, so Mr. Burnett, you do swear? All right, thanks. So you
Yes, sir.
already- All right, excellent. All right, your name is Tyler Shea Burnett, is that correct?
Yes, sir.
And Mr. Burnett, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Is it frozen? Is there a lag, Mr.
It's
Schmidt?
glitching. Yes, sir.
All right, well, just, if it happens again, just bear with me. All right, Mr. Burnett, have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his work that he's done for you?
Yes, sir, I am.
2 days.
Is there anything about your case, your plea agreement, the paperwork that you do not understand?
No, I understand everything.
Mr. Schmidt, you believe Mr. Burnett to be competent, and if so, you've explained to him his rights regarding this case.
Yes.
All right, Mr. Burnett, you are charged in cause number CR 23-175 by indictment with a third-degree felony offense of evading arrest or detention with a vehicle that does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and carries a fine, if imposed, of not more than $10,000. I see the plea agreement in your case is that you would plead guilty to that crime. The state's recommending that the court assess your punishment at 5 years in prison with a $1,000 fine plus restitution of $180, court costs of $290, reimbursement fees of $35. And as part of this agreement, the state is asking the court to dismiss your unauthorized use of a motor vehicle in cause number CR 23-174, the possession of controlled substance in CR 23-176, and also your evading arrest or detention in DA 23-58. You would receive 404 days credit time towards your sentence for time that you've already been in jail on this cause or on this specific case. Is that your understanding, Mr. Burnett?
Yes, sir, I sure do.
All right. All right, Mr. Burnett, then I want to ask you, how do you plead to evading arrest or detention with a vehicle?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, force, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, the stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, sir.
All right, the court's going to review the stipulation of evidence. All right, then the court reviewing the evidence finds that there is enough evidence to convict Mr. Burnett of this offense. The court hereby follows the plea agreement today, convicts Tyler Shea Burnett of evading arrest or detention with a vehicle, a third-degree felony. Assesses his punishment at 5 years confinement. The Texas Department of Criminal Justice orders him to pay a $1,000 fine, $180 restitution, court costs of $290, and reimbursement fees of $35. Furthermore, the court dismisses under section 1245, cost number CR 23-174, unauthorized use of a vehicle, cost number CR 23-176, possession of controlled substance, and DA 2023-58, evading arrest or detention. Court awards Mr. Burnett 404 days credit towards the sentence for the time that he spent in jail on this case. Mr. Burnett, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with the deputy to be found. Good luck, sir.
Thank you, Judge.
You're welcome.
Hey, you're trustee, right? You're trustee? Yes, sir.
Do we have anyone else that's ready?
Mr. Young?
If he needs
We need-
time.
Yeah, we need about 5 minutes.
All right, I'm gonna bring Mr. Lambert in.
Okay.
He is on Zoom. And let's see what we're doing on Mr.
Today.
All right, you'll just unmute for me there.
Hello?
All right, good afternoon. This is cause number CR 22-372, State of Texas versus Joshua Lee Davis. And I was looking for a final status on Mr. Davis's federal custody.
It's my understanding that what he's charged with in the federal system is essentially the same thing that he's charged with here. And they seem to be wanting to keep him.
Do we know where he's at in the prosecution of that? Has he pled? Is he being tried? Do we have any dates? Something that I can determine when I reset my case, or if I bench warning, or what we do?
Right. Well, I've reached out to his family and I wasn't able to find out anything from them.
Do you know if he has a defense attorney in the federal case?
I think he has an appointed defense attorney in the federal case. I haven't had anything to do with it.
So we don't have any updates about, we don't even know where he's at, how long he's gonna be there, what he's charged with.
Well, my understanding is he's charged with the same offense that he's charged here, but and it's supposed to be the same occurrence.
Same occurrence.
So I think it would be you are correct. We need to really know what stage he's at on that. You know, if he signed for something or if he's about to sign for something. That's my understanding. For the last I talked to his family, but I hadn't been able to get hold of him.
Okay, what about from the state? State, do you have any announcements on Mr. Joshua Lee Davis?
Your Honor, I don't. If the court would grant me just a few minutes to see if any of the other attorneys in the office do have information, I'll go check right now.
Okay, yeah, I was hoping for a final status today. I think this was filed back in November of 22. So, all right, so Mr. Lambert, if you could turn your camera off and your audio for just a moment. I'll stand in recess for about 5 or 6 minutes, and then we'll see.
That's fine.
We'll see if the state can figure out if they have a position on this case.
Okay, I'll try to do that.
All right, thanks, sir.
Good afternoon, Your Honor.
Good afternoon, Victor. How you doing, my friend?
I'm doing fine. Thank you so much for asking. How about yourself?
Oh, we're doing great. We're doing great. Tell you what, give me just a moment. I'm gonna go ahead and set up the interpretation system. And then I think our inmate is ready. I think they need just a moment to prep. I'm gonna go ahead. I can swear you in. We'll go ahead and set it up. That way when he hops on, you can go ahead and test it out. Make sure that we got a good.
Very well.
Let me go ahead and swear you in. Good. All right, Mr. Montemayor, if you raise your right hand and state your name and license number for the record.
Victor Montemayor, 1659.
Sir, do you solemnly swear or affirm that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment? So help you God.
I do so swear.
Let's see right here. I'm gonna go ahead and turn this on. All right, Mr. Schmidt, we have a good connection. I know it seems to be lagging again.
We appear to, from our end, yes.
Is connection good at this moment?
It appears to be.
All right, I've already sworn in Mr. Montemayor, so I'm gonna ask him to see if he can get a good line of communication with your client, and then you can get started. Yes, sir, I can hear you. It should be simultaneous, yes. Does it show to be set up on your side?
Yes, sir, we are. On the laptop.
He can, okay, he can hear you now. See,
Excellent, great, thank you. All right, this is cause number CR 23-132, State of Texas versus Josue Sosa. Court has acknowledged and recognized and sworn in Mr. Victor Montemayor as a licensed interpreter by the Texas Supreme Court. And Mr. Sosa, your name is Jose Sosa, is that correct? Mr. Sosa, are you a United States citizen?
no,
Mr. Sosa, do you understand that if you enter a plea today and the court accepts that plea, it may affect your legal status in this country and your legal rights to re-enter the country? Mr. Sosa, have you ever been diagnosed with any type of mental condition?
no,
Mr. Sosa, are you pleased with your attorney, Mr. Richard Schmidt? Mr. Schmidt, do you believe Mr. Sosa to be competent? And if so, have you explained to him his rights pertaining to this case?
Yes, sir, I have met with Mr. Sosa on several occasions with an interpreter on hand. We went over the documents I don't know, Saturday or two ago with an interpreter. I explained to him his rights as well as the potential immigration consequences of entering a plea. I believe him to understand those, and I believe he's ready to proceed.
Thank you, Mr. Schmidt. All right, Mr. Sosa, you were originally charged with a third-degree felony offense of theft of a material containing either aluminum, bronze, copper, or brass. less than $20,000 value, which is a third-degree felony. However, it appears today that the plea agreement you've reached with the state is to plead to a lesser included offense of theft of material containing aluminum, bronze, copper, or brass less than $20,000, a state jail felony, with punishment being assessed as a Class A misdemeanor. And the recommendation in your agreement would be 311 days in the county jail. You would receive credit for all 311 days of time served already, along with a $2,000 fine, court cost of $270, reimbursement fees of $520, and the state would be dismissing another unfiled charge of engaging in organized criminal activity. Mr. Sosa, is that your understanding of the plea agreement?
See,
All right, Mr. Sosa, then I would ask you at this time, how do you plead to a Class A misdemeanor theft of material containing aluminum, bronze, copper, or brass less than $20,000?
culpable.
Mr. Sosa, are you pleading guilty because you did commit this crime?
Hey.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, the stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further, Your Honor. Thank you.
All right, the court's going to, anything further from the defense, Mr. Schmidt?
No, sir.
All right, the court will review the evidence.
Okay.
All right, the court has reviewed the evidence, does find enough evidence to convict Mr. Sosa. The court hereby follows the plea agreement, convicts Mr. Sosa of the lesser included offense of theft of material, aluminum, bronze, copper, or brass less than $20,000, state jail felony, assesses punishment under section 1244B at 311 days in the county jail. Court awards Mr. Sosa credit for time already served, orders him to pay a $2,000 fine, $270 in court costs, $520 in reimbursement fees. Court dismisses under section 1245 the unfiled engaging organized criminal activity. All right, Mr. Sosa, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Have you stepped over with the deputy to be fingerprinted? Do you have any questions of your attorney or the court?
I do.
Go ahead, Mr. Chairman.
Well, Judge, I just wanted to call the court's attention to, I believe I might have misheard you. He's being punished and prosecuted under 1244B, a Class A misdemeanor. In that in other words, he's not being convicted of a state jail felony, he's being convicted of that Class A misdemeanor as well as punished under that same provision. I heard the court say he's pleading guilty to the state jail felony. So I just want to make sure it was clear for the record of Mr. Sosa that it is a misdemeanor.
What is the original charge level for theft of precious metals less than 20,000? My docket sheet says that it's a third degree, but that's exactly what the judgment says.
Well, Judge, it shouldn't have been. So basically, the dollar amount of the materials would determine the range of punishment. The negotiations with the state were to proceed under a state jail felony amount, which is the lesser included, and then prosecute and punish under 1244B. So originally it was a third degree 2 to 10 as indicted, but we should be pleading to the lesser included state jail level under 1244B.
What's the monetary value to make it a state jail that would then authorize 1244A or B?
And Judge, off the top of my head, I don't recall that. I do know that me and Mr. Hernandez did look at those amounts. The alleged victim in this offense did not submit a restitution claim. So there is no way to accurately calculate. I think though that based on us putting our heads together, we're fairly certain that it would have fallen under a state jail range. And I'm sure I don't have the code in front of me, but ultimately, I think even without that restitution amount, it would have comfortably fit under a state jail amount. If that answers your question, I'm not sure.
Well, really, all I'm concerned about is what the judgment says here, because this is all I have to go by, is this says less than 20. My docket sheet said less than 20 is a third degree. I don't know if one's correct or incorrect, but this one says less than 20, but down here it says, you know, class A. So my understanding is that it was a reduction. I was a little curious about how we went from third degree to 1244A and B, but it could be that this should say something different.
It could be that it should say something different, Judge. You're correct, and that's why I guess we're both on the same page as far as the confusion. It should be a lesser included state jail.
And that's what I'm pronouncing sentence on today. My understanding is that it is a reduction to a state jail felony. So whatever the offense is in that category, that's a state jail. The court is convicting the defendant of that. I'm going to ask that we make sure that the judgment accurately reflects that, and the court has assessed punishment under state jail felony 1244B as a class A misdemeanor. So B is punished and is convicted and punished as a misdemeanor. Does that clear that up?
Yes, sir. It does.
Okay. All right. So let's just make sure that the offense on the judgment for which it says defendant is convicted properly reflects a state jail. Then it'll be a reduction to that class A under 1244.
Thank you.
All right, Mr. Sosa, any questions?
Ok, y lo que va a pasar ahorita, ya el tiempo, ya o va a estar más tiempo aquí.
Mr. Schmidt, do you know if Mr. Sosa has any other holds in any other counties?
Judge, he did have an ICE hold, and so what I explained to Mr. Sosa is that the immigration federal authorities have 48 hours to execute their hold. If they do not, then he would be released. But he is aware that there is potential that they will take him into custody and deport him or go through the deportation proceedings. However, you know, it's really up to the federal government at this point.
Mr. Sosa, does that answer your question?
Sí.
Okay, all right, then Mr. Sosa, you're hereby remanded to the custody of the sheriff. If you'll step over with the deputy to be fingerprinted.
Gracias.
Thank you, Mr. Montanore. I believe that concludes our need for interpretation services. Appreciate you being here. Thank you as well. All right, Mr. Bartwell, quickly, anything on Mr. Lambert, Mr. Lambert's client, Mr. Joshua Lee Davis?
Yes, Your Honor. I was able to find out a little bit. There was a PSI done in December for the federal case. So we expect that just due to the timing in the federal system that he'd be sentenced sometimes in the next 2 to 3 months. We were also able to determine the defense attorney on the federal side is Mr. Thorson. So we'll reach out to him to try and find any further details.
Is that Brent Thorson?
Yes, sir.
Okay, all right, so Mr. Thorson comes here, okay. All right, so let's, did you hear that, Mr. Lambert? About
Yes, I did hear it, Your Honor.
okay,
And I did look up what your value was for your state jail offense. It's under 30,000.
under 30,000, okay. Well, I
So if
appreciate
it's under 30,000, then it would be a state jail felony.
okay, great, thank you, I appreciate that. All right, so let's reset then, you said 2 to 3 months. Let's reset for status. Let's reset for status on April 16th.
April 16th?
Yes, sir, April 16th, and let's get a hold of Mr. Thorson and find out if he can give us some more information. I would suggest the state and the defense do that.
Yes, sir.
Yes, Your Honor. If I might ask prosecution to email me the prosecutor's contact information when you get it.
Yes, sir.
Could you do that?
Yes, Mr. Harlow,
Yes, sir.
email Mr. Lambert.
Yes, sir. We'll get in touch.
Thank you.
All right, thank you, Mr. Lambert. All right, Mr. Schmidt, are you ready on Mr. Young?
Yes, sir.
All right, James Paul Young, CR 23-146 for arraignments. Go ahead, Mr. Schmidt.
Judge, I received a copy of the indictment on Mr. Young. His name spelled correctly. He understands the charges against him. We enter a plea of not guilty, waive formal reading, and ask for April 16th pretrial date.
All right, court finds that Mr. Young has waived the formal requirements of arraignment. Court enters his plea of not guilty into the record and sets pretrial for April 16th at 1:30. If he makes bail, of course, his hearing will be at 9 a.m.
Yes, sir. Thank you.
All right, Ms. Abraham, does that conclude everything in the jail today?
Yes, sir.
All right. I appreciate your work, and we are going to adjourn and go ahead and let some people get in here for a meeting here at the court.